our review of the bill, and our recommendation in relation to same. So this section is going to be in two parts. After my review, then we'll have the question and answer section. So once I'm done with the review, I'll throw it open to the House for any questions or observations or recommendation from the House. So I'll be sharing my screen. So can you all see my screen now?
Yes, please.
Okay. So like I said earlier, my name is Ezinne Ogbonna, and I am an associate in the firm of Niji Oni Co. So we have done a review of the National Digital Economy and E-Government Bill. And the bill is basically to regulate public services institutions, private establishments, individuals, and organizations coordinating digital activity in Nigeria, either partly or in whole. Now, we see this as a great step. However, this bill is in conflict with some laws like the Land Use Act, the Sale of Goods Act, and the FCCPC Act, right? And we are also of the view that it is very important to be careful in limiting laws and regulations as to digital world, because the digital world is always evolving. Several jurisdictions abroad, like the Australia, UK, and United States, in regulating e-commerce and digital governance, have enacted certain laws. Now, one of these is the United Kingdom. What we've tried to do is to look at several laws across other jurisdictions and how they've applied these laws. Now, that of the United Kingdom is the Electronic Communication Act, right? It's a very specific act that focuses on electronic signature and electronic communications. Now, the act was enacted to ensure that documents that are electronic and have electronic signature are enforceable as the same as their paper counterparts. The key focus areas are the electronic signatures, the cryptographic services, facilitation of e-commerce, and government and electronic communication. Likewise, in Australia, first they had the Electronic Transaction Act, which we noticed that the bill is modeled to suit the act. Now, the intention of the act initially is specifically for federal laws. It applies to federal agencies, federal organizations who use electronic transactions and communications, right? It is not compelling on private individuals, but however, where they are to send documents electronically to these agencies, they are to abide by the laws and regulations of the Electronic Transaction Act. Now, in 2021, the Australian Act was amended, and the Electronic Transaction Act of 2021 was passed into law. The amendment came about because of certain obstacles that the country has seen with the previous act of 1991. So they had to amend it to include certain exceptions. So these exceptions are issues like passports. The act is not binding on passport. You can still have your physical copy, your paper copy of your passport. Then statutory declarations. Now, some of these declarations require that it comes in a particular form. They have their requisite forms for these declarations. Now, the government has looked at all this and said, okay, yes, let these declarations be an exception to the Electronic Transaction Amendments. Now, coming to the bill. and its application in the Nigerian system. Section 2 of the bill, of the Nigerian bill, provides that where any information is required by any law to be in writing, recorded in writing or in printed form, or is described as written, notwithstanding anything contained in the law, now that requirement is satisfied if an e-form is rendered, recorded, or made available. It goes further in subsection 4 to say that where any information is retained in electronic form, in accordance with 2.1, the paper form of that document need not be retained. So let me give an example of what this act is saying. If I send you a letter and I have a hard copy and a soft copy, the act is basically saying that the soft copy is going to be taken as a copy of the paper form, and I can do away with the paper form. Now we have queries in relation to this. Our first query is as to admissibility of documents. Normally, admissibility of documents in courts is guided by the Evidence Act of 2011. The Evidence Act makes provisions for certain requirements for the admissibility of documents, which says that it can only be in its primary form or in its secondary form. Now, our question is, this document, is it going to be regarded as a primary document or a secondary document? We have the opinion that the law should be specific in what type of document it should be regarded as, whether it's a secondary or a primary document. Let me give you an example. In cases of tendering a newspaper document, the newspaper has been defined by law to be a public document. Now, where the primary of a public document is not available, the only acceptable secondary document is a certified true copy of it. Now, what this means is that if I'm tendering an e-copy of a newspaper publication, now by the provisions of section 2 of the bill, it says that even if I'm tendering a secondary copy of the bill, now the law accepts it as being admissible, right? But it failed to address that gap of whether it's a primary or a secondary document. Now let me go also to the issues of documents that are required by law to be in writing, because the section 2 specifically says that where it is required by law, which means that it must be a requirement of the law to be in writing, not just any documents. Now, there are certain documents that the law states that must be written. Example are deeds, like your deed of assignment, your power of attorney, your will. Section 9 of the Wills Act already provides that it must be written, it must be signed and acknowledged by testator in the presence of 2 witnesses. And then court cases have gone ahead to rule that the deeds of assignment must be signed for them to be validly recognized. So this section 2 did not provide any solution, or it overlooks that part of the law that says that these requirements are essential requirements for them to be recognized by law. Then going forward to section 6, we also notice section 6 of the bill that provides for retention of documents, records, or in electronic form. So section 6 provides for the requirements for certain documents to be adhered to. So our query as to that section is the criteria A, B, and C. A says the information contained in electronic form is accessible to be usable for subsequent reference, or B, the electronic communication is retained in the format in which it was generated, sent, or received in a format which can be demonstrated or represented accurately, and the information generated, sent, or received, and any information that enables the identifier of the origin and destination of electronic communication and the date and time when it was sent or received is retained. So are these criteria to be adhered to collectively or one or the other? So we are saying that the act should be redrafted in such a way that it will be very clear as to whether one or two of the criteria are to be adhered to, or that the three criteria are compulsory criteria to be adhered to. Now, admissibility of electronic records. So we are also going to the admissibility again, like I said before. Section 9 says that in proceedings in a court, tribunal, or arbitration, whether of legal, judicial, quasi-judicial, or administrative nature, the admissibility of an electronic document or an electronic signature in evidence shall not be denied on the ground that it's an electronic record or an electronic signature. Generally, the law recognizes electronic signature, so it is admissible in court. But however, when it comes to electronic records, there are laid down procedures of admitting or tendering an electronic record, which Section 8(4) of the Evidence Act has listed. So let me give an instance, like the instance I gave earlier of a letter. If I come to court and I am tendering an e-copy of a letter, now the opposing counsel, regardless of whether I certify it based on the condition in Section 84 of the Evidence Act, the opposing counsel would always raise an objection that, my lord, this is a primary document, this is a secondary document, sorry, and I have to lay foundation as to the whereabouts of the primary document, which is the original copy. Now, Section 9 of this bill, in its provision, did not take that into consideration as well. Going forward, we have the electronic contracts, right? Section 12(1)(b). So we are saying that this part is, Section 12(1)(b) is quite ambiguous. It says that if the electronic communication has not left an information system under the control of the originator or of the party who sent it on behalf of the originator, the time is when the electronic communication is received. So basically what Section 12 is talking about is the time of dispatch of an electronic document and the time of receipt. So the time of dispatch is very clear, that is at the time you sent it. Now, 12(1)(b) is saying that if the electronic communication has not left an information system, it is the time when the electronic communication is received. So we are saying that this is a duplication. We are at best, we are expecting that it should just be kept simple. The time of receipt is when it has left. The time of receipt is when the addressee has received the electronic communication. And at the time of dispatch, it is when the originator sends it out or when it has left the information system of the originator. So that way, it will eliminate room for debate as to when did you leave, when did you not leave, what time did you receive it? Oh yes, I was now aware, or you had issues, the addressee had issues with the communication system or not. So it eliminates that debate and that issue of dispatch time and time of receipt, just to keep it simple. Then the next one is Section 12(3). Section 12(3) says that the time of receipt of an electronic communication at an electronic address that has not been designated by the addressee is the time when the electronic communication becomes capable of being received. So this caters for issues, as we said, at the time It said at an electronic address that has not been designated by the addressee. So we've read it, and what we interpreted it to mean is that maybe I went online and I found out an email address of a company, right? That was not provided to me by the company, and I sent an email to it. Now, there might be issues because that email address might be functional or it might not be functional. Now, to eliminate certain issues, we have looked in-house, and our position, our suggestion is that there should be provision for prior communication of addressees' electronic address. And we can educate companies that any information you put on your website, or agencies as well, any information you put on your website should be accurate and is deemed to be accurate. So in case there's a change tomorrow or anytime in your address, electronic address, place of business, phone numbers, the website should also be updated accordingly. Because based on this, it is presumed that any information on an agency's website, on a company's website, or an organizational website is correct. Now, the originator does not have that obligation to know if your address on your official website is working or is not working. So there should be a prior communication, which could be by way of your email address, and anything put out there in an email address in a website by an agency or a company is presumed to be an accurate information. Electronic signatures, requirements for electronic signatures. Section 16 says that where it is required by law that a document should be signed or provides consequences if the document or record is not signed. Now that requirement is satisfied in relation to an electronic record if a method is used to identify the person or to indicate that person's intention in relation of the information contained in the Electronic Act. Like I said earlier, that there are laws that require that a document should be signed. Now, our question is, does this provision do away with electronic signature? Bear in mind provisions like the Wills Act and property law and the effect of unsigned documents in law. Now, this provision is saying that if I'm to sign a document and another method, maybe face identification or fingerprints, any other thing, is used to identify that my intention was to enter into an agreement with A, right? Now that method is deemed to be acceptable, which takes us back to our previous review on the requisite ingredients of a will or of a deed of assignment, that it has to be in writing and it has to be signed. So now the will even goes further to say that it has to be acknowledged by the testator in the presence of two witnesses at a time. Now, this section did not take into cognizance of all these laws. So it's going to create ambiguity, and it's going to create a lot of debate when it comes to application. We've also looked at the effect of an unsigned document. Case laws has ruled that an unsigned document is inadmissible and unenforceable. However, there are exceptions to this, but generally, an unsigned document is inadmissible and unenforceable. We move to section 36 of the bill, which provides for vendor information. The provision of the bill says that a vendor shall provide a consumer with sufficient and relevant information on the product services to enable informed decision on the part of that consumer. Now, such information shall be clearly prescribed in a language the consumer understands. This is not practicable. It says in a language the consumer understands. Certain other laws like the NAFDAC Act and the FCCPC Act provides for information, labeling information to customers. NAFDAC Act says English language and may include any other language. So if I don't understand, if I just go to the market and pick up a product, right, and their labeling is in an English language, and I don't understand English language, I don't expect every manufacturer to produce their labeling instruction in every language applicable across different regions of Nigeria. So it should be the official language, and any other language if they choose to. English is the official language, which the NAFDAC Act has provided for. Then the FCCPC Act goes further to say that in case of notice of document or visual representation, you can produce it in a prescribed form. So if there's a prescribed form for a particular product, then the vendors should adhere to the prescribed form. Now, if there is no prescribed form, it should be in a plain language. Right? It goes further to say that for the purpose of this act, a notice document or visual representation is in a plain language if it is reasonable to conclude that an ordinary consumer of the class of person for whom the notice, document, or visual representation is intended. So say, for example, I'm a vendor and I sell cosmetics products or pharmaceutical products or drugs, whatever product I sell. Now, my labeling should be in a plain language that an average educated person should understand. So saying that it should be in a language the particular consumer understands is not achievable. So it should be in English language or any other language, or it should be in a language that an average person should understand. Then we have section 39 that talks about minimum information in electronic commerce. So this one is just a duplication of the other. 39A and 39B says the same thing. Terms, conditions, and method of payments, and details of and conditions related to withdrawal, termination, return, exchange, cancellation, and refund policy information. Same thing as the B, details of and communications related to withdrawal, termination, return, exchange, cancellation, and refund policy. So A and B is basically the same thing. So we just believe that one should be eliminated for the other. Then offensive and contravention 2 is duplication of, we find section 61.2 to be a duplication of section 4. While section 61.4 says that for a first offender, you pay the fine of not less than 1 million naira for a person, and then 10 million naira for a body corporate. For a second offender, 3 million naira for a person and 13 million naira for a body corporate. Section 61.2 just says 10 million naira for a body corporate. So we believe it should be very specific and avoid duplication. These are our observation. Then with general recommendation. Like I earlier said, as to regulation of digital and e-commerce transactions, these laws have been duplicated in different ways, like the FCCP Act, the Sale of Goods Act, the SON Act, and all of the NAFDAC Act and all of that. So our recommendation as a firm is that just like the Finance Act has introduced certain amendments to different laws, different applicable laws, and the Business Facilitation Act has also done the same, we have the opinion that just drafting a law on its own and calling it an e-commerce law is going to cause a lot of restrictions, and it's going to cause a lot of arguments as to which law supersedes Am I going to abide to this FCPC Act, or am I going to listen to the E-commerce Act? So what we recommend is that these laws, these applicable sections across boards should be amended rather than creating a new law, rather than drafting a new law and implementing a new law. So you come through all the applicable, business applicable laws, agencies, regulations, all the laws, and amend the specific sections that are required to suit e-commerce, e-governance, and electronic transactions. So thank you very much. That's it from my end.
Yes, thank you, Ezinne, for that review and deep work that your team has done on this. So the floor is open now. Typically, we're just going to do section by section feedback from members and stakeholders on the call. And I'll still let you, Ezinne, lead the feedback session as well. And people, so the floor is open for comment and feedback. So if you'd like to speak, please just raise your hand. I know Ezinne will call you to speak. If you also prefer putting in a text, you can use the chat box to do that. Thank you. Please, time for feedback or further input. I know we've got some input from members some on the call. True, you still like to make further comments or contributions on this call, please feel free to raise your hand or drop them in the chat. In case we also like to clarify some of the provisions of the policy, please feel free to indicate. Thank you. Yes, Peretimi, I know you mentioned you would like to make your feedback on the call. Are you able to do that now? Any more comment, feedback, questions, additions to what has been presented? Okay, so Ezinne, I think it's good to assume that everybody on the call agrees that your team has done a very excellent job on the policy, and the feedback you have presented is a good one that the association can present on behalf of our members and the ecosystem. Without further comment from participants on the call, I think that will just be the end of the review session. We will put together all the feedback we've got and share the draft feedback with all of us, and give it a few days for further feedback or contributions before we finalize and send them down to the ministry. So thank you, Ezinne and team, for facilitating this session. Everyone, please do have